that he's from. Yeah. But remember her from church? Yeah. That's
till 8. All right. I'd like to call tonight's meeting of the Board of Zoning Appeals to order and ask Danielle for a roll call when she's ready.
Randy Jones,
Present.
John Dilberger,
Here.
Darla Brown,
Present.
Jane Gore,
Here.
Andy Boyles.
Present.
You all received copies of last month's meeting minutes. Had a chance to review. Are there any changes to suggest to those minutes?
Aye.
I'd entertain a motion to approve them as written.
So moved.
Second.
Danielle, a roll call vote on approving last month's minutes when you're ready.
Jane Gore,
Yes.
John Dilberger,
Yes.
Andy Boyles,
Yes.
Darla Brown,
Yes.
Randy Jones.
Yes.
Okay, minutes are approved. We have an item of old business, which is docket number 25-SC-15. This was something the petitioners requested that we table until December 18th meeting. I don't have a problem with that.
So moved.
I'll second the motion.
Okay. We have a motion to table the docket number 25-SC-15 until the December 18th meeting. It's been seconded. Roll call vote when you're ready, Danielle.
John Dilberger,
Yes.
Andy Boyles,
Yes.
Darla Brown,
Yes.
Randy Jones,
Yes.
Jane Gore.
Yes.
Right. Next item on the agenda tonight is docket number 25-A-02. This is a request to appeal a decision made by the Brown County Area Planning Commission Director regarding issuance of a sign permit. Kayla, a staff report whenever you're ready.
All right, staff report for appeal of director's decision. Docket number 25-A-02. Hearing date November 25th, 2025. Petitioner Penny Scroggins. Request appeal the decision of the planning coordinator, director of the Area Plan Commission regarding issuance of a sign permit. Ordinance provisions, Chapter 7, Administration, Enforcement, and Appeals, and the Board of Zoning Appeals Rules of Procedure, Article 5, Powers and Duties 1A. General history. 1, the petitioner is requesting an appeal of the director's decision to issue a sign permit for KOA on May 28, 2025. 2, at the time the determination was made, the appeals process was explained to the petitioner. Under the Board of Zoning Appeals Rules of Procedure, an appeal must be filed within 45 days of a decision, and this timeline was met as the petitioners produced an application for an appeal of the decision on July 8, 2025. 3, the appeal was docketed on August 4th, 2025. The legal notice was published in a timely manner, and the petition was slated for the August 27th, 2025 BZA meeting. 4, the Board of Zoning Appeals heard the petition on August 27th, 2025, and decided in favor of the petitioners. 5, after the decision was made, it was realized that an error had been made during the docketing process, and notification was not sent to all interested parties as required by the Board of Zoning Appeals Rules of Procedure. 6, once the notification error was realized, the board agreed to rehear the petition. The rehearing was scheduled for November 25th, 2025, and the decision of the board will be based on this rehearing. The docketing procedures were completed by staff. General findings. 1. In the zoning ordinance, 7.5 appeals provides a decision of the planning coordinator enforcing this ordinance may be appealed to the board by any person who is adversely affected by the decision. For filing fees, see Chapter 8, Section 8.2, and on an appeal under subsection A, the board may make any decision that the planning coordinator might have made. 2, the Board of Zoning Appeals Rules of Procedure, Article 5, Powers and Duties 1A states, the board shall have the following powers, and it shall be its duty to hear and determine appeals from, sorry, there's something right here. Hear and determine appeals from and review any order, requirements, decision, or determination made by the director in the enforcement of the Brown County zoning ordinance or the Nashville zoning ordinance. All appeals must be filed with the commission within 45 days of the order, requirement, decision, or determination made by the director. 3, according to the petitioner, there was a sign in the same location many years before the petitioner purchased the property. The sign was blown down during April of this year. It is unclear when the original KOA sign was placed on the parcel, as a sign permit was not found. 4, the sign sits on property owned by the petitioner, but which has an easement named KOA Drive for the KOA campground. The easement reads, a perpetual non-exclusive easement for ingress and egress over and along a 50-foot wide established roadway leading from State Road number 46 to the above described real estate. 5, the petitioner is the owner of a tourist home property located at 2298 State Road 46 East, as well as 5 additional adjacent tourist home properties. The home most affected by this sign is under construction currently. The petitioner has provided a petition with 118 signatures asking for the sign to be taken down. And I'm trying to go forward on my slides here. There we go. 6, Carpenter Legacy Management is the current owner of the KOA campground. A special exception was approved on January 29th, 2014, under docket number 14-SE-1 to operate a travel trailer park and campground. Historical reports from staff state that the property was used as a campground for approximately 40 years prior to the necessity of a special exception. 7, according to the zoning maps, the Scroggins properties are zoned GB, general business, while the KOA campground is zoned FR, forest reserve. The KOA's newly installed sign is located on the GB property and is 80 square feet. There are vastly different maximum sign area allowances depending on where the sign is located. 8, on the sign permit application form, it is stated that written proof must be attached to this application of owner permission if application is made to allow a sign on property that is not owned by the applicant. 9, during the application process for this sign, staff made KOA representative aware of this requirement. 10, in a letter from Clendening, Johnson, and Borer, PC, attorney representing the KOA, staff was made aware of a Court of Appeals of Indiana First District decision, Wendy's of Fort Wayne, Inc. versus Fagan. The judgment in this case was the trial court's finding that the grantee of the easement has, quote, the right to erect the directional sign in the easement because that use is incidental to making the grant of ingress and egress effectual. Indiana cases clearly have held that the owner of an easement possesses all rights necessarily incident to the enjoyment of the easement, and that he may make such repairs, improvements, or alterations as are reasonably necessary to make the grant of easement effectual. Summary, after reviewing the case law, staff granted approval of the application for a sign permit in the easement as staff interpreted that the trial court found that a grantee has the right to erect a sign to make the easement effectual. All right, that's the end of the staff report.
Thank you, Kayla. Any questions from the board for Kayla?
So, if I'm to understand right, we are rehearing the case
Correct.
as if we haven't before.
Correct. The decision should be made off of what's in this board packet and what happens at this hearing is.
All right. If there are no other questions, I see the petitioners here tonight. Did you want to add anything to Kayla's staff report? Anything to share with us? Yeah, if you come up to the microphone and identify yourself for the record, I'd appreciate it.
Hi, I'm Kurt Scroggins. And as far as any new nothing has changed since the last meeting, so I didn't think I had to go over everything that I'd said last time, but after I reviewed the sign ordinance permit process, I did notice one spot in there that said that the signs must have a setback from the State Highway 46 right-of-way, and just wanted to note that the signs are on the right-of-way line or in the right-of-way. I'm not sure which, but if you did grant the permit to put the sign up, they do need to be set back from the right-of-way line. That's the only thing new that I've got.
All right. Before you leave, Dave, Mr. Scroggins, of course, gave testimony at the first public hearing. Are we allowed to consider that testimony and the exhibits he presented, or does he need to re-testify and re-present?
Well, this is a new hearing,
Yeah.
so I would say that would be the safest practice.
Okay. All right. Then, does anybody have any questions for Mr. Scroggins? Anybody from the board?
I'm
yeah,
sorry.
you go ahead.
With
You first.
respect to the measurement that you were referencing, did you take the measurements?
Which measurement are you
Well, you're
talking
talking about
about?
the offset from the State Route 46.
Setback.
Setback, I'm sorry. Have you taken those measurements?
I measured the sign height, and it's approximately 16 feet high. So I'm assuming that means it's supposed to be 16 feet back from the right-of-way line. And the sign is on the right-of-way line right now. So I'm hoping to take the sign down completely, but if it does end up being put up, it does need to meet the setbacks, I feel like.
Put some pictures of the sign in question and then another sign, but she didn't give any information about those. It looks like the sign in question is in front of this tourist home that's under construction, is that right?
Yes, they do have other signs there that I feel like constitutes the ingress egress thing that the state showed in the Wendy's versus Fagan. You know, they have a sign there showing where the road is and where their campground is. I just don't want that big, huge sign that's right in my front yard blocking my view of, you know, the golf course and the pretty aesthetic Brown County landscape.
Okay. So this sign sits in your view that otherwise looks at the golf course across the road?
Yes. And then a lot of the ordinances, you know, I just keep reading over and over in the purpose and intent section that, you know, signs are supposed to be aesthetic looking, they're supposed to blend in with the landscape, they're not supposed to cause any hardship on any property owners or anybody adjacent to the sign, which this sign does all that.
You said there's another sign, is that the smaller one that Kayla showed a picture of?
Yes, there's another sign across the road. They have a propane filling sign there. They have a KOA drive sign. They have a KOA sign on the KOA drive sign. So they've got like 4 signs on the opposite side of the drive. We're just arguing this one sign.
Okay. All right.
So, Mr. Scroggins, if I'm understanding you correctly, your primary objection to this is basically line of sight aesthetics.
Yes, that's the biggest thing.
Okay.
And Ms. Scroggins, initially when you had reported to this board, you had talked about what happened, the events after the sign blew down, that you had made contact or that they had made contact with you, and it was made known then that you didn't want it. And can you walk us back through that? Because I don't remember the details.
Yeah, in the very beginning, when we first bought the property, we were opposed to the sign then, and the previous owner was also. And he had went to the county planning commission, and they told him it'd been there long enough that they weren't going to make him take it down. But they said if anything ever happened to it, then it would have to be, you know, back to a legal sign, and it would have to be permitted, and they'd have to approve it. You know, I'd have to approve it since I'm the landowner. I told them then that, you know, we'll wait and see, you know, someday it'll come down. I wasn't in any big hurry. But when the winds blew it down in the spring, we all thought, okay, it's down, you know, it'll be done. We don't have to look at it anymore. Well, not too long after that, maybe a couple of months after it blew down, you know, he was erecting it back up, put a new sign up, a little bit bigger than what was there. And I confronted him and told him, you know, you need to have a permit to put that sign up. And he told me that he did not need a permit. He was an American, he paid his taxes, he could do whatever he wanted. So I said, okay. And we even called the sheriff, and they sent a couple deputies out. They talked to him, and they said that they didn't know enough to really do anything. So then I went back to the planning commission and told them what happened, and told them again that, you know, I didn't give him permission to put that up. So they said, okay, we'll not issue the permit. We'll tell him he needs to take it down. Well, at that point, then he got a lawyer, come up with this Wendy's versus Fagan up in Fort Wayne, had some type of, whatever that case was, that said that they could put a sign up. But in that decision, it said, you know, a mere 52-inch sign could be put up because it was a hardship case. There's no way anybody could find it. So I'm looking at, you know, the smaller signs on the other side of the road takes care of that point. So now I'm back to the big sign that's just in our view.
So you're not opposed to the other 3 signs? How many other signs are there?
No, the signs on the other side of the drive is fine. We don't care. That's, you know, we're business people too. We would want a sign showing where our business is. And we've got a sign there that says Bear's Den for our vacation cabins. You know, I'm not against signs. It's just this one huge sign that's in my yard that he's got lights shining up, you know, it reflects. It's kind of a reflective yellow sign. You know, if you're sitting on my back porch looking out at night, you know, it kind of blinds you. Light shines back at the house. You know, I just feel like it's not a necessary sign.
So you said, Mr. Scroggins, that your objection to the sign was it blocks your line of sight from your house. Would it be possible, or would you be willing to, assuming that KOA has a right to put a sign in the easement, would you be willing to enter some sort of encroachment agreement with them to have them put the sign somewhere else on your property, just not there? And would that even be practical? Because I know on the east side of your property, you've got a bunch of trees and it looks like it's hilly, so I don't even know if that would work, but.
Yeah, I don't feel like it would. You know, any of the signage that's on the west side of KOA Drive is fine. You know, I'm okay with anything up and down through there. But anything on my side where the cabin is, it's just not feasible. I don't feel like.
All right, I understand. Any other questions for Mr. Scroggins? No? Okay, thank you.
Okay, thank you.
Is there anybody else here tonight that wants to speak in favor of this petition? Oh, yes, the co-petitioner, of course.
I'm assuming, Penny Scroggins, I'm assuming I need to be up here again, since I was already here a few months ago.
Well, this is a new hearing, so if there's anything you'd like us to know.
There's nothing
for
new.
this year.
Everything is the same as when I was here before, but do you need to hear it all again, or?
It would be helpful for us to
Okay.
hear it again. As Randy said, Andy said, our memories aren't always 100%.
Okay. Well, the sign obstructs the view from our cabin, and the view is of the Salt Creek Golf Course, which is beautiful. As outlined in the county zoning ordinance, the goal is to maintain and enhance the aesthetic environment of Brown County, which I think is important, and we all think that's important. The sign is 8 foot wide by 12 foot tall, which is more of a billboard than a sign. And they already have 3 other signs. You know, the Wendy's case allowed 1 sign in an easement, not 3. So, you know, and we're not arguing about the other signs across the easement. It's just this one that is in the view of our cabin or the view from our cabin overlooking the golf course. And I think that's all I have.
Okay. Any questions for Ms. Scroggins?
I mean, Kurt pretty much said it all. I don't want them to not have a sign. I just don't want this sign in this location. Across the drive is fine. Sure, they need a sign. People need to be able to find KOA. Although I happen to think that you don't jump in an RV and then try to find a place to go camp. You usually have a destination in mind, but that's neither here nor there. They have a right to have a sign. They're a business.
All right, thank you for that.
Good evening.
Yes, sir.
My name is Tom Densford. I'm a lawyer in Bloomington with Barbara Densford. I was asked by Mr. and Mrs. Scroggins to come down and address any legal issue.
Sir, could you get a little closer,
Oh,
adjust
excuse
that microphone, just so that they
How's
can
that?
record it?
Is that better? Yeah. Anyway, I was asked to come down and address the legal issue that's been raised, has to do with this case of Wendy's of Fort Wayne that's been cited in the staff directory and the staff report. And there are parts of that case that are clearly not in dispute in terms of an easement and possessing certain rights. This easement happens to be ingress and egress, which means they can come and go. But they don't have the right necessarily to unilaterally expand the use of that easement. For example, they probably couldn't use it for large commercial vehicles or expand it, the use to include residential developments back in that road. So when you acquire an easement, you're stuck with what it is you acquired. And in this case, they acquired a right to have vehicles come and go across the property. They want to expand that use to include the sign. So the burden is on them to demonstrate that that expanded use was permitted or was contemplated under this easement, and it simply was not. It referenced simply ingress and egress, not signs, not utilities, not any other expanded use. The case that is cited is rather unique to that particular situation. In that situation, there was no obvious point of ingress and egress. Is that how do you find this business? It was 261 feet off the main road. So in that case, the court found that the purpose of the easement included the right to put up a very small sign at the entrance to allow employees, customers, suppliers, and others access to the property that would be rendered virtually meaningless without the installation of a directional sign. Well, that's clearly not the case here. There's 3 other signs that are available to locate this property, and it's called KOA Drive. It's not a mystery to someone traveling down the state highway where you turn off to get to this place. So the finding there, or any reliance on this case, is somewhat expansive of what the actual holding is, and also expansive of what easement rights were acquired by the KOA camp when they purchased this property and began using that road some decades ago. So that's really all I have. I brought a copy of this case that I'd like to provide to Mr. Schilling in case there is some question about the legal authority and the citation to this case is present.
Thanks. You're welcome, David. Before you go,
Yes, sir.
If I could just ask you a couple of questions. So you mentioned the fact that in the case that you are talking about, the business wasn't visible from the road. I believe this business isn't visible from the highway either.
No, but the point that it wasn't visible made the sign that much more important.
Yes.
In this case, this large sign is less important because there's 3 other signs that people can use to find the business. It's not essential to people locating the business, and that's kind of what distinguishes this situation from that particular legal precedent.
Okay, thanks for that.
Any other questions?
Yes. Were you reading directly from the findings of the court then?
Yes, sir.
Were you quoting that? Particularly about the sign section there as far as, okay.
Yeah,
So you
I was reading about the court's finding that this particular sign in
Right.
Fort Wayne was incidental to the ingress and egress because it was necessary for customers, vendors, suppliers, and guests to find the business. So that part of what I was, that part of my presentation was read directly from the case.
Okay, all right, thank you.
Thanks for that.
Thank you.
Is there anybody else here tonight that wants to speak in favor of this petition? Okay. I'm assuming some of you folks want to speak against this petition then. I'm going to let you decide what order to take it in.
Apologize, I gotta get my ducks in a row here.
Oh, that's fine.
I noticed you picked a yellow animal.
Sorry.
He'll get it.
I'm a little disappointed in that you yellow suit. That worked.
Okay. I don't need pens. I just like to throw them on the ground, actually.
Okay.
I really don't like them. I'll probably throw more. My name is Alex Martin. I represent KLA Campground, Carpentry Legacy Management. I would just obviously like to thank the board for being here for that, reconsidering this matter. This matter, though, this sign is a dispute about KLA sign that sits along the driveway that leads to the KLA Campground. KLA Campground, that's not it. It's in the back. You can't see it from the road. And this sign has been here for some odd 40-something years with no issues pertaining to this sign. And then, of course, Scroggins move in, a storm blows this sign down, and that's kind of where this whole thing started. And that's no surprise. The Scroggins own their own business, Bears Den Vacation Cabins, which is very akin to the recreational camping cabins the KLA Campground runs. So it's no surprise that they have a little competition here and there. And that's fine, and that's, as they said, that's fine, competition happens. But what this really is about isn't about the sign placement. It's not about whether or not the sign is ugly or not. This is about stifling competition unfairly through the means of this procedure. But aside from that, I would just respectfully request this board to hear what has to be said and respectfully allow the sign to stay. A few points of contention first that I will address for the legal matters. First of all, the case that is being relied upon, Counsel Tom Dinsford stated it's kind of incidental to that matter, that they couldn't find it, that they couldn't find the business. Can't find KOA either from the road either. If you're coming and heading east, you can't see the sign that they actually are talking about that's okay. That is okay. There's foliage there and it's only a one-way sign. But you can't see the campground either. You can see that cabin, which you might believe is KOA, but it's not. It's actually in the back. Second, the egress or the easement that was given in Fort Wayne does not mention using it for signs either. In fact, it says this, and I will quote the case. The executive of an easement which provides in pertinent part, Wendy's, does grant to William P. Fagan a permanent easement and right-of-way for the purpose of egress and ingress from the real estate. The easement shall be for the non-exclusive use and benefit of Fagan, and Wendy's reserves the right of use of real estate contained within the easement not inconsistent with the grant for purposes of ingress and egress from any part of or all of the land owned by Wendy's abutting or adjoining the easement. The easement shall include the right in Fagan, its successors, assigns forever to enter upon and within the easement to maintain, repair any roadway, street, drive, constructed over the easement, and to do all things necessary in regards thereto. Nothing says that it grants that they can place a sign, just like the easement in this. It's a grant for an easement for ingress and egress, just like this one in Fort Wayne. And once again, if we're going off of the fact that you use the easement, placing a sign in there to effectuate the purpose of the easement, this satisfies that. However, I want to reiterate that this is not an argument about the constructual or contractual interpretation of an easement. This is rebutting or refuting a valid sign permit. This isn't about arguing about whether it's valid through the egress or ingress of an easement. This isn't anything to do necessarily about law. This is about how they have to show that this sign is invalid after obtaining a valid permit from the Planning Commission. The primary argument, first of all, is that they say it's ugly. And, you know, beauty's in the eyes of the beholder, as we all know. But the problem is that just because it's ugly doesn't mean it's not valid. Or even if it isn't, it's not ugly to begin with. But what I'm saying is the subjective determination of whether it's ugly or ugly for this board should be put aside. It's whether or not this sign is invalid up against a valid sign permit. And looking at the requirements from the ordinances, this is a valid sign. This meets the requirements. It's 8 by 12. That's still less, it's 96 square feet. That is less than the sign requirement of either one single sign being 100 square feet or total area signage being 144 square feet. The signs that they're talking about on the other side, though, don't effectuate that purpose of this easement. One sign is covered by foliage when you head the opposite direction, and it's only 4 by 4. Can't be seen from the road when you're driving eastbound. Could be possibly seen from the road when you're driving westbound. The little tiny sign is a 1 by 4 sign, which is 4 square feet, which is not regulated by the guidelines of the ordinance. And so even if you did take all of the square footage signage, it still is less than 144 square feet in any particular area. But so there's that part about the square footage of the sign is being too big or anything like that. It meets the requirements of the ordinance. It's a valid sign. The second thing I want to point out is, if you look at the picture here, what is being built and what is already constructed? I mean, when they built this cabin, they knew that the sign was there. It's not like they didn't see it. It's not like when they didn't know when they were planning out when to build the cabin that this sign was going to not be there or be there at all. I mean, their whole hopes was, we don't like the sign. We're going to hope for something bad to happen to this sign. Unfortunately, something did happen to this sign. And now they're mad because the sign is back up there. And it's legally back up there. But the whole point of their argument is that, well, that sign's ugly and we want to move. Move your cabin. Don't put the cabin right behind the sign. You see the sign, you see where it's going to be at. Why would you put your cabin right behind the sign? You can move the cabin over. You can move the cabin back. You could do anything other than put your cabin right there when you know the sign's there. I mean, they're complaining about the sign being here, and then they built the cabin right there. So just take that into consideration when you're making your decision, please, is that the sign was there first, the cabin was there second. So I implore you to at least consider that. In regards to the multiple other signs, I've already talked on this, and there might be an issue with the 3 signs. There is no requirement under the ordinance that limits the number of signs. Now, we understand that this could possibly be read as, You could put 100 signs up there, which I understand that. But that's why we have the total square footage area under the sign regulations, under the guidelines. And the ordinance does prescribe numerical limitations in other areas. So the drafters of the ordinance understood that it could have put a sign limitation in a certain specific area, and it didn't. Just because there's one ugly sign, two ugly signs, as the Scroggins say, there could be 20 ugly signs. So long as they meet the square footage requirement, which this one in particular does, and it's a valid sign permit, they have to show something more than it's ugly. It has to show something other than that. And that is where the reliance on the Fort Wayne case is misconstrued. That is not a case invalidating a board zoning appeals decision. That is a case in which the property owners have actually filed a lawsuit to enjoin, and it's a deck action. They're asking the court to interpret an easement as to whether a sign can be there. And the court said the sign can be there. I understand that that was a mere 52 inches, but that is something that's a moot point because it's not invalidating the sign based off of the size of the sign. It's validating the sign because of the fact of the interpretation of easement. So I don't want this board to get twisted. This is about a valid sign permit, not about a valid easement. The easement is valid and the sign's valid, but I don't want the board to get confused on that matter or maybe twist it around for that. And I just want to clarify that issue.
Just a point of clarification real quick. Your office presented us with the Fort Wayne Wendy's versus Fagan lawsuit, right?
Correct.
Okay.
And that is the reason why we used that case was because when you apply for a sign permit, you have to have permission from the owner of the land, the landowner, should it be on someone else's land. The use of that case was to demonstrate that an easement that we had obtained from the prior owner is an implicit, we don't need explicit permission from the landowner. By a matter of law, we have the permission we need already. That is what the easement satisfies. And that was the purpose of that whole throwing that case in there, was to show, and subsequent cases in there, was to satisfy the requirement under the permit application that we didn't need the Scroggins written permission because we have that easement. And that's the reason for throwing that case in there and for citing that. It wasn't to argue that the easement was valid or that any placement along any right of way or anything like that was invalid or valid. It was just to effectuate that purpose that we do not need express written permission from the Scroggins as a matter of law. The easement satisfies that. But now I just want to kind of take a few closing remarks in terms of KOA. First of all, there's 118 signatures supposedly from the Scroggins to take the sign down. That's fine, but it's a valid sign. It's legally entitled to be there. 118 signatures is moot. But KOA is a trusted national brand. It's got huge economic impact on any community it goes into. This KOA specifically brings in approximately 18,000 guests per year. So those visitors, they come into Nashville, they support your local businesses. You guys have lovely arts and crafts shops here. You guys got some great restaurants. I come down here very frequently. And those 18,000 people that are drawing in, they benefit not just Nashville, but the community at large in Brown County. And this sign, it's large enough to be seen in inclement weather. When you're driving, much like today, it's foggy, rainy. When I was coming in, you can see that sign coming in from Bloomington. You can see it. It helps the travelers find where they need to go. As we all know, we kind of live out here in Brown County. GPS isn't necessarily the greatest thing to be using, but that sign helps travelers when they're coming to Brown County to stay at KOA. So yes, they do have a second sign, but they're not really looking for that. When I was coming here today, I wasn't looking for their smaller signs. I'm looking for the giant, big KOA sign, the national brand sign that recognizes that I am there to stay at their campground. And this sign, it's large enough so that people driving caravans, trailers, hauling camping gear can see in time to slow down, make a stop, and turn safely. It's not just because it's there, just because they want everyone to say, hey, look at me, here's our campground. It's big enough so that everyone traveling can see where it's at. People hauling large loads and heavy trucks can stop on time, RVs, and make a safe turn. Travelers, they don't just look for the sign to see where KOA campground is, they rely on the sign to get there safely. And so I just respectfully ask that this board allow the sign to stay, hold that the permit is valid, and I thank you all for your time.
All right, any questions from the board? I had a couple of questions.
Yeah, of course.
You referred several times to this sign, but it seems like you were referring sometimes to the old sign that blew down and sometimes to the new sign. We're actually talking about two signs, right?
No, this is the same. This sign got blown down, and then, if it's my understanding, it got put back up, and then it got taken down.
That's
And-
not my understanding,
Okay.
so I'll ask for clarification.
Okay.
Maybe you'd want to clarify that. I think that this is not the sign that blew down, this is a new sign,
This is the same sign that, this is the same sign that blew down.
Exact same sign.
exact same sign.
New post, same sign.
Okay, so it's the post that fell, and it fell off the post, and you put it back up with a new post. Got it, okay. And you spoke about a valid sign permit. What is it that makes a sign permit valid?
That it meets the requirements that are required by the planning commission under the ordinance.
Well, it doesn't meet the requirements, I guess, because it doesn't have the landowner's permission.
But the easement already by law allows for us to put a sign there regardless of the Scroggins permission. This is what the easement is for. The easement is to effectuate, that sign being there effectuates the purpose of the easement pursuant to the case law, Fort Wayne and the subsequent cases.
Well, actually, Wendy V. Fagan sets up two tests to decide if the sign actually is permitted. And one of them is it necessary to effectuate the purpose of the easement for ingress and egress? And what I'm hearing is that there are multiple signs there. Why is this sign necessary when the others are not?
Yeah. So first of all, the first sign, the small sign, is 4 square feet. You'd miss it if you weren't looking at it. It doesn't effectuate the purpose of the easement because you can't see it from any great distance unless, of course, you're standing right there on top of it.
Okay.
The second sign only faces in one direction.
I think we're seeing a picture of that second sign you're talking about, the small one.
Correct. So the small one is over here off screen. There might be another one. This one.
There it is. Thank you.
It's fairly small. It's 4 square feet. You'll probably miss it if you're not looking for it, especially in inclement weather. You will miss this sign.
Okay.
And then if you want to go to the second sign. This sign only faces one direction, so it faces east, so only traffic from a westward direction can see it. This road bends back here, and there's foliage behind it. You cannot see this sign until you are clear of the foliage, which would not effectuate the purpose of the easement because the distance between there and there is not so far away. It doesn't effectuate the purpose of the easement if you're heading east because you would never see the sign, you would never know where KOA is at. You would drive right past it until you saw in your rear view the giant yellow KOA sign sitting in the back there, and then you'd say, I got to turn around on a hilly road. So
it's
I would
your
argue-
contention if I'm driving east on Highway 46 here that I won't see this sign until I've passed the driveway?
you will not see the sign until it is almost too late to pass the driveway. You would see it probably right in this area. Whereas the bigger sign, you can see those posts. The sign's obviously down. You can see those posts sticking up above this foliage and clearly around this bend. You can see the top of this post, and then when you get closer, you can actually see the sign laying on the ground before you can see the eastward facing sign. Also, I'd like to point out that there are no illuminating lights like spotlights. They are garden lights or something of that effect that will allow people at nighttime to see the sign when they're driving. It's not like they have a big Batman sign posted right there in the window of that cabin. It's there to make sure that people driving at night, inclement weather, or anything like that can see the sign. But to your point, Mr. Dilberger, I would argue that those two signs do not effectuate the purpose of the easement. This big sign would be the purpose for that easement, yes. I'm sorry, did I answer your question, or, I'm sorry, I didn't mean that.
Hold off a minute.
Like a teacher out here, sorry.
Yeah, no, I want to explore this a little bit further. So So is it the size of this sign that makes it work where the other sign doesn't? Or is it the location that makes it work? Or is it the illumination that makes it work?
So I would say it's a combination of all of them. The size of the sign allows people to see it from a greater distance. The illumination allows it for people to see it at night. And its position relative to the driveway and the road allows people to see it around corners, bends, or anything of that nature. So I would say it's all three, and the reason for those are there to effectuate all of those, to effectuate that purpose.
Okay, all right. So if I hear you right, then if the sign to the west were larger, as large as this sign, and if it were illuminated like this sign, it still wouldn't effectuate the easement because of its location.
Correct.
Okay, so you're arguing that the location of this sign is necessary to effectuate the easement.
Yes.
Okay.
I have one more question, somewhat rhetorical.
Okay.
Kayla, could you go back to what we're referencing as the small sign?
Yeah, I did a poor job of labeling my signs here.
Are we talking about this sign here or
smallish,
the
the smallest
KOA drive?
sign.
Okay.
The one that's on the.
Yeah, so that sign you said was approximately 1 foot by,
It is 1 foot wide by 4 foot tall. It's 4 square feet.
okay. Do you see the blue sign on top of it?
Yes, I do.
Okay. In this county, all of the road signs are printed on a steel backing like that road sign, but they're green,
Mm-hmm.
okay? That is what the county uses to indicate where roads are and what they are.
Okay.
Cross sections, intersections, county roads, there's a sign. And they're from Nellie Sisson to Grandma Barnes. We got some interesting names on signs, right? So they vary in length.
Yeah.
But they're all 8 inches tall.
Okay.
And green, which is, for most months out of the year, the color that is they're surrounded by. This vertical KOA sign is both wider and longer and yellow, a yellow reflective material. So if all the other road indicating signs in the county are that size, wouldn't you think that that would be big enough to indicate where to turn as well?
I would argue no. And the only reason for that is because it's not big enough in order to figure out, if you're coming around, if you're driving and you're looking for a sign and you're sitting up tall in an RV, that's going to be below you. You're going to be wanting to look at your eyesight. I would say it's too small. It's only 4 square feet. I mean, it's really, I know it looks a lot bigger than it is, but 4 square.
I'm very familiar.
Yeah,
I've
yeah.
hit the big sign multiple times with golf balls, unfortunately, them that bad. So it's my fault, I apologize.
But this sign, I would argue, is not big enough to effectuate the purpose of an easement, no. To effectuate, to signal to individuals driving that is where KOA would be located.
Okay, and that was 4 square feet, so 8 square feet, because it's two-sided, right?
Well, I would argue there is no definition in the ordinance that says that a two-sided sign counts as 2 signs.
Okay, I don't know, I'm certainly not an attorney. Kayla, could you go to the medium-sized sign? Okay, and how big is this one with the propane filling
It's a
station?
4x4. So it's 16 square feet.
Okay, so again, every other sign in the county to indicate a road to know where to turn is less than 4 square feet.
Okay.
So that's approximately 4 times that size and bright yellow. Are you following where I'm going here? Like, if it's to effectuate the ingress and egress, both of those also exceed the minimum. I totally get, from a branding aspect, I want it as big as I could. I get it. I totally understand. But you can't say that these they don't affect ingress and egress because they're bigger than all of the county signs put together.
I will say that the regulations governing county signs is different than that of governing commercial signage.
Governing, yes, because that's state budget stuff.
Yeah,
Like the
and I'm
state
not
would
quite
handle
sure if that yellow one is reflective or not. I was there during the daytime. I didn't.
it. I don't know, but Could be.
I mean, it could be, but I would argue, I don't think it, and I'm getting head shakes here from my clients here, that it's not. But I think, you know, to see where your point is that this sign is bigger than most county road signs and most bigger than most signs, sure, only if you're coming from one direction. If you come the other direction, you're looking at the back of a mat, and that's I mean, you're looking at the back of a sign. It's just wood back there. So you wouldn't see that sign until A, you got close enough, and B, you wouldn't know it's a KOA sign until you passed it.
But maybe that location could have a bigger sign.
Maybe, possibly, but again, you'd have to get past the argument that there's foliage. So you'd have to either cut down the foliage or make the sign so big that it could be seen coming around the bend over there.
So are your clients, is their argument on this sign more for direction or for information? Is this sign, your clients, do they consider this sign more direction or for information?
It could be for both. It can inform individuals, the KOAs here, just as if I'm not camping today, but I drive on this road and I look at it and I'm thinking, oh, KOA campground, okay, that's great. Maybe I want to take my girlfriend for a camping trip or a family, or maybe we want to go do a family thing. All right, cool, advertising. So then all of a sudden I decide to make that choice. I'm driving, it's nighttime, anything like that, and I think, oh, my GPS isn't working. Where's KOA? I know it along this road. Driving. Oh, there's KOA signs right there. Got it. Turn in this driveway. Obviously, it's not going to be the giant cabin that's labeled Bear's Den. Keep on going back towards the back, and that's where you're going to find it. So it can be used for both, but in two different circumstances.
And you're basing the legal validity of this on the easement, is that correct?
I'm basing the legal validity of the sign on the planning commission's granting the permit for the sign. I am relying on the easement for the purpose of that I do not need to go to Mr. and Mrs. Scroggins to get written permission because of the fact that I have that easement.
You're saying the easement allows this sign to be...
The easement allows this sign because the sign perpetuates or effectuates the purpose of ingress and egress back to KOA's campground.
Correct.
Because you cannot see the KOA campground from the road. It's up a hill. Fairly steep, I walked it today. So.
Wendy's v. Fagan also sets another test that we're supposed to pay attention to for a sign on an easement, and it says that it should not amount to an offensive burden on the serving estate. We've heard the Scroggins testify that they consider this an offensive burden on their property. Is it your contention, your client's contention, then, that it doesn't constitute an offensive burden?
Correct. It does not constitute an offensive burden. For two reasons. One, again, I can't stress this enough, the Fagan court is not overruling a BZA decision. This is not a court that's saying that the commissioners or anything like that has to make that determination. The purpose is because in that case, Fagan sued Wendy's, actually sued them to get the sign off. And the court said that the easement that was granted from Wendy's to Fagan allows for a sign to be placed so that it can allow its customers to go to the auto body shop or the business that Fagan ran. So it's not directing the BZA to bring that into a factor when it makes determinations on the validity of a sign, I guess. It's as directing it in terms of it's a factual difference, a different fact pattern. They're deciding the rights based off of an easement. That is something that is more along the lines of, this is the valid easement, here's the sign. Also, I mean, whose harm is it anyway? It's 52 inches. But they're not saying that they have to go back to the BZA, argue in front of the BZA or the commission that this is that this is something that causes an offensive burden. They're not directing that, and that's not what it is. It isn't a remand back to the BZA to take that into consideration. It's a decision on the court that says that you have legally binding easement, and that's really what the holding of this case is. It's not whether or not someone has a 52-inch sign or is offensively burdensome to certain extents. And that is that is that holding that issue.
I'm feeling like there's a distinction without a difference here.
If I may as well.
Oh, okay.
Yeah, sorry, it's just that the second point I have goes back to the fact that you have an offensive burden because the sign is there. So when the Scroggins purchased the property, the sign was there. So if that's the time that they determined that this was an offensive burden to them, why would they put a cabin right behind the sign? They are complaining about a situation that they put themselves directly into. The sign was there first. I mean, you know, and I'm not saying chicken or egg or anything here, but I'm saying that in the terms of the matter of its offensive burden, the one way to avoid the offensive burden is to not put a cabin right behind a sign that's going to offend you.
I understand.
So that would be, I mean, that's, you know, so, but those are my two talking points for that question.
Okay. Well, with respect, I mean, we at the BZA here sit as a quasi-judicial body, and we were not the ones that reached back to case law, and that actually was you who reached back to case law in order to inform us.
Correct.
And so it seems a little disingenuous to do that and then ask us to not pay attention to the case law where it doesn't suit you.
Well, and I'm not going to get into an argument regarding the legalities of case law. And I do understand that the administrative body here does take on quasi-judicial roles, but the judicial interpretations from the board are taken as, you know, it's not given difference if this were to go to a court. The court would review it based off of however the court wants to read it, really. And I'm not saying that it doesn't hurt, help, or I'm not taking it into a genuine consideration, and I don't mean any offense to that. I'm saying is that the issue in Fagan is not arguing a valid sign placement. They're arguing whether the easement allows for a sign to be placed in the first place. Here, in this situation, we are arguing that our sign is valid, that it has a valid permit, and that it should stay. The only reason why the Fagan case was mentioned was to show the planning commission that we did not need the written permission from the Scroggins because of the easement.
But what he's trying to explain to you is even though your case law doesn't say that, our county ordinance does. That
Correct.
You are required, according to our ordinance, to provide the plan director with written permission from the landowner to erect a sign. It's in the ordinance.
Correct.
And
So should we follow our ordinance, or should we follow the case law that says we don't need the landowner's permission?
Well, if you follow your ordinance, then you would probably likely deny our sign. And then we would go to the court and make the argument that we don't need written permission in the first place, and then we would follow what the court can say. So I can't obviously direct you on what decision you would make, obviously, but I'm not challenging you on that. I'm just saying that those would be the two turn of events that would occur if this is the line of thinking that would be going down from the board's decision. Just following from a merely procedural aspect on where our argument would lie, if that is where this issue would be honed in on, that's where the issue would be on in the judicial review as well, and that's what we would be arguing for as well.
Well, we're very much aware of the fact that all decisions are subject to judicial review if such is.
Correct.
So, right.
Yeah, and I'm not making this
I
problem.
think we agree on that, so we're aware of that fact.
Okay.
So with regard to that sign, why couldn't you put a KOA sign on the other side and then put garden lighting under it? What you described as garden lighting?
What my clients have decided, I don't know the reason for the sign being up there in the first place in terms of what was the thought process behind putting the sign up there in the first place. But it could be just merely because there was a different need for a bigger sign. It could be that sign was there in the first place before the big sign occurred, and it doesn't have a backing to it. I can't pin on the original landowner putting that sign there or anything of that nature. And then, of course, turning around and putting the big sign up as well. I can't determine the reason why the original KOA owners put those there.
So I want to make sure that I fully understand this as far as the timeline on the sign. That sign, the one that's out there standing this evening as we're speaking, are the same size, has been there for 40 years, except for the short period of time the storm came through and took it down.
Not that sign.
Not this sign,
The big
the big sign that we're talking about.
I'm sorry, this sign right here, the big sign, I said the one that's out there now.
Yeah, correct, yeah.
Okay, the same dimensions, in the same location.
May I?
Is that correct?
Yes, it was there for 40 or 50 some odd
Wait a
years.
minute, I'm getting a yes and I'm getting some heads
Yeah.
nodding this
Okay.
way,
Do you
so.
have access to the internet? Are you connected to this?
I am.
Can you go to Brown County GIS? Please?
Well, right now,
Wait, I'll show you a representation of that sign standing in place 20 years ago that you have access to.
20 years ago.
20 years ago. There's an overlay from Putnam County GIS in 2005 of that sign standing there 20 years ago.
He's the original owner. Ask him when he wanted to sign up.
well, all right, please, we're gonna take testimony one at a time, just so we can keep things organized and keep our records straight. If you want to talk to, are you the client?
One of, yes.
If you want to talk to him and clarify to answer Randy's question, that's fine with me.
Yeah, there's open source intelligence on
Yeah.
Brown County GIS.
The way that I understand is that sign's been standing for at least between 40 and 40 years.
20 years.
So yes, correct,
Okay,
the sign was standing.
there is written documentation, or photographic documentation, or mapping documentation to show that that sign has been there for at least 20 years.
Yes, 2005.
Okay.
1974 was the original sign.
I can verify that the sign's been there since 1980 if it helps. Well, probably 89.
All right, that answered my question. Okay,
I apologize for the confusion.
No problem.
I think there was a question about the square footage. It is the same, we were, I believe we were told in a previous hearing that the new, after it blew down, the one that went back up was larger, the backing or whatever, the size, what was put back up was larger.
So it is a factual clarification that it is actually 8 by 12, not 8 by 10 because of the holiday, the holiday sign attached to the bottom, where it's connected to the bottom of the KOA sign. So it is 8 by 12, it's 96 square feet.
and the previous one was 8 by 10?
The previous, yeah, I'm sorry.
That's what I heard you say.
Is the previous one 8 by 10? I thought it was,
No, it's always been that.
it's always been this. So again, I apologize, it's always been apparently.
Okay.
So, per KOA franchise agreement, the regulations
Wait,
were.
he needs to identify himself.
Oh, would you step up to the microphone,
Yeah.
please?
We record these meetings and
I
stuff. so-
understand. Caleb Carpenter, Carpenter Legacy Management.
Mhm.
So per KOA franchise agreement, KOA mandates that the top portion of that sign be 8 by 8. And then the rider that's underneath is what the holiday is called, is the addition to that. And that's what we've established has been there for at least 20 years.
Okay, thank you.
So
Thank you.
8 by 8
8 by 8 is the top portion.
is different than 8 by 10 and different than 8 by
He
12.
just spoke that that was a clarification issue on actual measurements,
Okay,
that is an 8 by 12. And then the holiday is that's the 2 feet to the bottom. I'm sorry,
Well,
8 by.
I was gonna say your
8 by
math
10.
ain't mathing,
Yeah, 8 by 10, you're correct, 8 by 10, and the holiday has 2 feet to the bottom.
but you said the agreement is 8 by 8
For the KOA. So
for
it's
mandate.
per KOA franchise agreement, the top portion, where you see the KOA in yellow, you see the difference in the yellow in the sign.
Right.
Is 8 by 8. That's
Okay.
what they provide, that's what they say.
But that is not 8 by 8. That is 8 by 10 plus 2
The
feet.
holiday adds the additional 2 feet to the bottom. As a
Right.
rider. So that's a clarification to the type of park that it is. If it were a resort, it would say resort. If it were a, nothing other than a base park, it would just be KOA.
I'm not trying to be difficult, I promise, or obtuse. 8 by 8 plus 2 is 8 by 10.
Correct.
That is 8 by 12.
The height overall is 8 by 12. You've
Then
got-
where is 8 by 8? I don't understand. You
You
said,
have
lost
2
now,
feet.
too.
Yeah,
you said 8 by 8 plus 2.
2 feet, 2 feet of air underneath it.
Oh,
You're talking about air below it.
he's talking about the height of the sign, not the square footage of the sign.
Right.
And it's actually less than
Yeah.
12. We're just presuming it to be the top, the sign portion itself, 8 by 8 in the yellow square, 2 more feet of holiday, 2 feet of air.
I wasn't, the air had, I was like, man, listen, I'm not great at math, but that doesn't work. It just doesn't add up.
I will represent to you guys that the sign, this sign, just the total sign, we're talking up and over is 8 by 12.
Well,
How about 8 by 10 with 2 feet of air?
With 2 feet of air.
Yeah, that is correct.
I don't understand the 2 feet of air, because that wouldn't count towards your square footage.
The actual signboards.
He's talking
Signboards,
about
the signboards that have been
not
there
square.
for 15 years at least. This exact sign has been there for 15 years.
All right, we'll get to your testimony in just a minute. Any other questions, Mr. Martin?
Well, I'm not sure I should have brought that subject up.
Are you pleasantly puzzled, or?
What I wanted to make sure of.
It's clear as mud, right?
You made comments this evening that that sign has been there. That sign, the one that's out there tonight, has been there, and I heard the word 40 years, and I heard it revised to 20 years. What I want to make sure is that we're comparing apples to apples on this. That is the exact sign, size, width, length, everything, in the same location.
Correct.
20 years ago.
That is correct.
Is that a safe statement? And you can prove that through documentation? Okay, thank you. That's all I need to know.
Okay, so for me, if you'll help me,
Yeah.
we've been talking about a valid sign permit. If this is the same sign that's been up there for 20 years and it blew down and then was put up again a few months later, did it need a sign permit?
It was, yes. So I reached out and spoke to Matt Fitz from the Planning Commission, and he indicated to me that yes, even though this sign had existed for some odd years, it was the Planning Commission's goal and intention to bring all signs into conformity with requirements from the Planning Commission, which then of course kicked off us filing for our permit. So we did try to ask for a grandfather in, and that was kicked back.
Logan Fitz.
Logan Fitz, yeah, not Matt Fitz, I'm so sorry.
Okay.
Okay, all right, thanks for that. Any other questions for Mr. Martin?
Are we going to put a time limit on each person, or should we take a small restroom?
I want to see how it goes. Do you want a small restroom break before we proceed?
I'm just saying, if we're, got old man over here.
Why don't we take a break for a few minutes and we'll resume at 7:15.
It's always me. I apologize for delaying this, everyone. 30 more seconds. Just forgot.
She texted me too.
Yeah, he said that was a little bit.
Yeah, let me see.
There's a tax on golf balls, I'll tell you that.
Truer than you know, my friend.
It's a sport, it's a sport.
All right, looks like everybody's back. I'll resume this public hearing and ask if there's anybody else here who wants to speak against this petition. Do not see it.
Do you want to speak?
I would. Oh, well, if you could come to the microphone and or we can take the microphone off and bring it to you. There you go.
Make sure you turn it back on.
I think you can stay there, sir.
Okay, I talk pretty loud. I'm used to that anyway. Okay, thank you very much. I don't,
Oh, and who are you, sir, for the record?
okay, Ernie Forrester. I'm an ex-KOA owner. I was there in 70, I guess, in 78, there about 15 years. But all I wanted to comment about the sign was, and the right-of-way, when I bought the place, they made all of that. We had a 50-foot right-of-way, we had signage there, and KOA's parties, the size. The size of the sign was always been KOA. If you travel on vacation with your camper, you'll see that big sign. It's almost in every campground, that's just their sign. They put us a sign, I put them up and maintained it. I probably changed it 3 times while I was there. So you say it's been there 20 years, it's not, but it's been up and down. And the zoning commission's never questioned me when I done the work on the signs. So I just figure it's a grandfather cost. What else can you do? And why could you take it down? That's just all I'm gonna say. Thank you.
Thank you, sir. Anybody else who wants to speak against this petition? Yes, sir. Oh, you're putting the microphone back.
Go ahead, Mr. Brady.
My name's Chuck Braden, I'm just a citizen here in the county. I'll just say that the sign's a landmark, and it's been there since the 70s. People use it as a landmark. It's part of the atmosphere of Brown County. That's all I'll say.
One more time, is there anybody who wants to speak against this petition? I don't see anybody. Any questions from the board for anybody that we've heard from that haven't been asked?
I have one, but it sticks in my mind that at the last hearing, it was said that that was not, the one that's there now is not the one that blew down.
Yes, that's my recollection as
dreaming,
well.
or-
No, you're not reading me. That's my recollection as well. Ms. Scroggins, would you come up to the microphone if you have something to speak to this? Because I have that same memory.
I have a photograph of the sign that was after we purchased the property.
Okay.
Would you like to see it? I think it was in the original packet, actually.
Yes, I would like to see that.
I don't think we have the original copy.
that, you have to go right ahead. That's the sign that was up when we purchased the property. That's from the MLS listing when we purchased it.
Okay, and how is this differentiating from this one over here? Is it just-
Well, it doesn't say holiday at the bottom, and it appears to be closer to the ground. I don't know if it's foliage in front of it or what, but that's from
You're right,
the
it's
original
not 4
listing.
feet off the ground.
Yeah. Did you see it, Jane?
I want to see.
You're the one that asked.
We'll get it to you, Jay.
Okay.
It appears that
This one's,
it's tall,
yeah.
but
It could be,
it's
I
hard
don't,
to.
you know, I just had that from the listing, I didn't.
When you get the chance before you go tonight, we'll need you to email that to Kayla.
Okay, I can do that. I think I can send it to you, but I'll send it to you.
I don't remember seeing this one.
Okay, all right.
May I see that one more time, please?
And I have one quick question for you, sir. You had mentioned looking up Putnam County GIS.
Brown County.
Okay.
If you look at Brown County GIS, you can go to tools on your mobile, be tools, and then layers.
If you guys direct me to do that, I can show you the screenshot.
Why don't you give it a try, even if it takes a few minutes?
The only difference is that that one does not have holiday on it. Is that correct? The 2 by 8
Jen, yes, that's correct.
panel.
Kayla Carpenter, again, Carpenter Legacy Management. So the holiday was actually added on. It was actually up in the shop. KOA was actually a little upset that it hadn't been placed on there yet. So it had been missing for some time, and then it went back up when the sign went back up. Part of our branding. It's part of the branding because of the designation for that type of part. The upper portion of that is just the KOA brand logo is the same.
And what layer did you say to toggle on to see that?
2005.
I've got it pulled up on my
It's the
computer screen, but it's not showing to the side screens.
Of course it's not. What are you trying to do here?
No, I promise you.
Well, we can look at it on your laptop if necessary.
I'll print this out and put it in the packet too.
All right.
Well, so you're saying, there's not a Google Earth view where you can look at, you can just see.
Well, no,
that
they
there's-
didn't have Google Earth view back then.
But I'm saying,
2005, But you can clearly see the shadow from the sign
Right.
in 2005, the
Oh,
exact
good.
location that it's.
Oh, it's just showing that a sign was present at that
I
location?
believe that this is what he's put out here.
I can confirm that a sign has been there as long as I can
Yes, I see it.
remember.
And then when you lay it over
Here's Kayla
GIS, you
Gregor.
could also get a reference for property lines
So it's about in the same.
and see its distance from
This was supposed to be what, when?
from the
This
state road.
is 2005 photography.
I don't trust their GIS.
I don't either, but if you look at how that road lays, if you look at how the road lays, it's gonna adjust further south.
But we don't know if it's exactly
I'm,
the
I'm,
size.
I'm perfectly content to accept that a sign like that was there 20 years ago or 40 years ago. I got it. And yes, that clearly shows a sign was there. Gotcha.
But I think we've just been proven that there's something different about this current version than the original version. Am I incorrect?
All that was added was the rider on, all that was added to that sign was the rider on the bottom.
I understand, but we were making a point that that is the same sign, that it has not increased in size.
It's 3 pieces. That sign is constructed in 3 pieces. And the top 2 pieces are the same. They went right back up onto new post. The post rotted off and broke, so those signs just went onto new post.
How tall were the old posts?
They're the same size.
Yes, that was, they're 16, I think it's 16 foot posts, we cut probably 2 feet off of it.
Cut off the top.
Yeah,
We're actually lower now than we were.
yes. And I would argue, since I'm up here, if you've got GIS up, you can actually use the measurement tool, and you can cite the line, make the line of sight argument, and you have to consider, from a safety standpoint, why it's pertinent to have that sign in that location and that size. The largest rig that's been in there today was just over 80 feet long. That's a semi. Now, you put yourself in the shoes of a semi moving at 50 miles an hour, 45 mile an hour zone, 50 miles an hour trying to get stopped, and they're coming from Nashville. They need that visual reference to know what they're in for. And without it, if you move it to the other sign, you put a smaller sign up, which is not, what that violates our agreement with KOA. If we put a smaller sign up, that won't work for them. But the location of it actually, I mean, it would be more suitable to be even further east and south would make it even more visible for a safety standpoint. So it's already compromised where it's at.
So you're saying you would be willing to move the sign further to the east or west?
If it were.
I heard east and south.
Yeah,
Not west.
it would be, from a safety standpoint, if you're going to put that in the most ideal place where you have the longest line of sight to see that sign, it would have to actually move further south and east further off of our easement onto the adjacent property. So it's within the confines. I think you can't see it. Right here. Because of the
Okay. Anybody else has something they want us to hear about this? If not, I'm going to bring this back to us on the board to discuss and reach a decision on. And we get to hear from each of you in turn to start with. Jane, you never get to go first.
So we do now have a signed, approved sign permit in this packet now.
Yes.
I mean, not timely filed, but filed.
You mean a written policy?
No, a sign permit. A sign.
Excuse me, I would like to correct, it's a timely filed sign permit. We did it with.
Can you go to the microphone if you're gonna?
Sorry. Alex Martin once again, for KOA. It is a timely filed sign permit. Speaking with the planning commission, we filed it. We actually got an extension in order to file it because by the time that my office had received word that they were in violation, I actually reached out to the planning commission and got an extension for 2 weeks. And that's when we timely filed it. So it is a timely filed permit. It is not untimely.
Sorry, Jane, I didn't mean to interrupt.
Sorry.
So are you asking, did Kayla issue a sign permit?
Yeah.
And the answer is yes.
I did, yes.
Okay. And the petitioners are challenging her decision.
Yes.
Say she made the wrong decision to issue that permit. Okay. Any thoughts about whether or not you want to grant their appeal or not?
Well, I was one that voted that we on the side of the petitioners, but I'm.
Well, now you've heard new testimony though.
Right, I'm going to change my mind.
All right. You care to explain what's made the difference? Just for us?
Because that's the original sign. I was with the understanding that it was a new sign, a bigger sign, but it's not. It's just in compliance because it has the holiday on it now that it didn't have the holiday plaque. It didn't have it before.
So your thinking is they don't need the landowner's permission as our ordinance says
Well,
because
yes, I
this
do
is...
think they do need that with our ordinance.
You do? Okay. Well, they don't have it. So why wouldn't you grant their appeal?
Good question.
Yeah. Oh, wait, think about it. Randy?
Dave, question for you. You've heard all this testimony and information that's been expressed here this evening. Has your legal opinion changed since the previous one, or are you still contend that the easement allows for the sign to be there? And I don't want to put words in your mouth, but...
No, I would just say that that's the issue for you guys to decide tonight, is whether the sign cases that were cited would satisfy the requirement of a property owner's permission or not.
And I think your recommendation would be, did you have a recommendation on whether you think it does or does not?
I think that's for the board to decide.
Sounds a lot like I do not recall, council.
Any thoughts you want to share with
Well, the
the
way
rest
I
of
was,
us?
I'm sorry, what?
Any thoughts you want to share with the rest of us up here on the board?
Well, the last time I voted, not in favor of petitioners, because based upon what I thought I'd heard Dave say, and also the recommendations of the staff, it seems to me that they have a right to place that there just based upon the allowance under the easement. I'm not convinced that they have to have the owner's permission, because I'm wondering if the easement does not transcend that and allows for that to take place. So I guess
something that supersedes our ordinance, is that what you're saying?
well, yeah, there's a lot of things that can supersede our ordinances, but
Well, I'm asking because, you know, the attorney for the campground said that we can't let, the legal cases that they brought before us and stuff, that doesn't influence our decision as a BZA.
who you,
While at the same time saying that we have to pay attention to certain parts of those cases.
who are you quoting?
Mr. Martin,
Yeah.
you made a point that we aren't to be influenced or controlled by case law that he brought before us.
If I may.
Well,
Yes, sir.
We're actually, let them finish discussing first, because right now technically we brought it back to the board.
Thank you.
Not that we don't still need input, but let them finish their.
I'm on the spot now.
I'll let you think about it.
Well,
Unless you don't want time.
You listen through talking.
yeah, I voted, I'm going to keep my vote the same way that I had it last time, based upon what I've heard, the testimony. I felt like it was fairly compelling. The sign has been there for 20 years. We have evidence of that. I understand the petitioner's concerns. I'm sure it could be somewhat of a visual obstruction to what you would like to see, but I think the evidence that I've heard, I think, really is weighted more towards allowing for the sign to remain.
Okay. All right, you want to go next?
So last time I decided reluctantly against the petitioners, and I'm going to reluctantly decide against them again for the reasons that have already been discussed. I think the point of our ordinance to require permission from the landowner would apply if there were an easement there. And so I went into some detail at the last meeting about why I didn't like a lot of stuff, a lot of language in the Wendy's of Fort Wayne case, but I think it does apply. The sign was there first, the cabin was there second. Just as a side note, it would be nice if KOA would talk to your neighbors. At some point, you're going to have to go down to Bear Hardware and get something. So that's neither here nor there. So I am not going to change my vote.
Andy?
I don't believe that I've been shown, I'm not sure how to say this. I believe I'll keep my vote the same as previously stated. The sign was erected before the permit was issued. It was taken down after a order from our office was asked them to. According to our ordinance, they are required to have a homeowner's signature for a valid permit, that's in our ordinance. I believe section 4:15 in our ordinance also talks about a necessary effectual. Let me find the verbiage that I'm wanting to say. Is the sign necessary to effectuate the easement? The answer is no, it's not absolutely necessary. There are two other signs, or the other location work absolutely, they exceed what the county uses to dictate where roads are now. So I don't see the need for that to effectuate the ingress and egress. The argument was made that people need to see, I understand, but like a digital billboard, I mean, is that, if we're going for bright and loud, you know, we've dealt with this previously in this county with other national brands. McDonald's wanted to put up a lit sign, the golden arches, they're iconic for it. I would say it's almost as iconic as the KOA logo. They fought tooth and nail with the county. We have a sign ordinance that says you can't have lit signs. It didn't meet the ordinance, we didn't let them do it. But they still don't have it. They have an externally lit sign. Now, whatever you feel about lit signs, we have an ordinance that we follow, and that's what this board makes decisions off of. The other one would be, I tried to write it down, but I can't read my writing. There we go. Section 4.15 of Brown County zoning ordinance entitled miscellaneous sign provisions states that among the purposes or objectives of section 4.15 are minimizing the possible adverse effect of signs on nearby public and private property. An example, the adverse effect of obstructing natural scenic vistas or maintaining and enhancing the aesthetic environment. I don't believe, I understand it's a brand thing. I think that there's a solution here both ways. And I'd love to see that worked out. But as far as my decision this evening, it's going to be based the same as it was before. I think it needs to come down.
Okay. All right. Jane, anything else you want to add before I talk? Okay. All right, here's the way I'm looking at this. Based on what I heard tonight, Mr. Martin's client is not challenging the fact that they need a sign permit to erect this sign. I've heard testimony that suggests that this sign is a different sign than the one that was originally up there, but that makes no matter. They, once informed of the fact that they needed a sign permit, they filed for a sign permit, and they received a sign permit. The question before us is, was that sign permit issued properly, or should it not have been issued? And the reasoning that the petitioners are giving is that our ordinance requires the permission of the landowners in order to erect a sign. Mr. Martin, on behalf of his client, is telling us that we don't need to pay attention to our ordinance because the his client has permission based on Indiana case law that sets a precedent. And that precedent is that you can have a sign on your easement and the landowner doesn't have to give permission. Permission is automatic, if you will, based on case law. Now, the case law that he's referring us to says that there's two conditions to decide whether or not you're permitted to put up a sign on an easement for ingress and egress. One is it necessary to effectuate the purpose of the easement? We've heard a lot of testimony tonight that this sign is not necessary to effectuate the purpose of the easement. You can find KOA Drive from the several other signs that already exist there. Setting aside GPS or a map or anything like that, there are signs there to effectuate the purpose of the easement. The case that Mr. Martin cited also says that that sign, if you decide that it is necessary, should not place an undue burden on the subservient estate. An offensive burden is the language that's used. We've heard testimony that in the opinion of the petitioners, this is an offensive burden on them, this sign that's erected here. So, in my mind, the case law precedent doesn't apply here. It doesn't override our ordinance. Our ordinance governs here. And our ordinance says that they need the landowner's permission to put up this sign. And so for that reason, I'm going to grant the petitioner's request. Does everybody understand my reasoning? Okay. All right.
Yeah, very well put.
Okay.
Um,
Any further discussion then?
Yes.
Go ahead.
I would like to allude to what Darla had said earlier, that it would be nice if the two parties could come together and do some discussing and talking about if there is some common ground here on resolving this issue. That's not something for us to dictate here with this board, but just for the sake of community civility, I think would be really positive move to, if that can be done, for that to be done.
I tried.
Pardon me?
I tried.
Okay. I'm not asking for any comments to what I just stated. I'm just going to lay it out there and leave it, and that's all I have to say.
All right, then, Mr. Martin, you look like you wanted to share something with us?
Yeah, I just had a quick, forgot. Gotta go to the podium, sorry.
It's so that when they listen to record minutes,
No,
we know who said what.
I was just confused on Ms. Gore's decision. I didn't catch it, I guess, and I just wanted to know what the decision was from Ms. Gore.
Well, I guess we'll get her final decision when she votes, but you're welcome to explain your reason.
Oh, I didn't know if she voted or I
haven't voted yet.
No, okay.
When I bring this back to the board, it's for us to discuss among ourselves.
Got it,
I'm
okay.
sort of leading that discussion.
That's okay. Thank you for clarifying.
Yeah, no problem.
He was getting to that before I interrupted with my unsolicited comments.
Well, all right, so I've lobbied as effectively as I can. I don't think I can lay out my reasoning any better than I just did.
I would be willing to make a motion.
All right?
Make a motion to approve docket 25-A-02 with the reasons being no valid landowner's permission at the time of permit, so that it kind of makes the whole thing invalid. And that I don't believe that particular sign, that particular size makes, whether it's there or not, makes that easement ineffectual. It doesn't stop anyone from coming or going. And that, well, and it is causing, because it causes undue, whatever that verbiage was, eyesore on the prevailing estate. I'm not.
No, that's fine.
Those are my reasons.
So if I understand right, what you're making a motion that we grant the petitioner's request to reverse the decision of our planning director to grant this sign permit.
Correct.
Because our ordinance requires the permission of the landowner and the planning director did not have that permission.
Correct.
And therefore, she made her decision in error. Okay. Okay, I understand. I'll second that motion. Any discussion on the motion? All right, Danielle, roll call vote when you're ready. This is on the motion to grant the petitioner's request to reverse the decision of the planning director to grant the sign permit.
Andy Boyles,
Yes.
Darla Brown. No. Randy Jones,
No.
Jane Gore,
No.
Ron Delberger.
Yes. Okay, the motion fails. Further discussion then?
On this particular case? Or just
Yes.
in general?
Unless someone wants to make another motion. I am leery myself of throwing our zoning ordinance out the window, which it feels like we'll be doing if we do not grant this request. Because if we choose to grant to deny this request, let Kayla issue a sign permit without the permission of the landowner, then we're basically invalidating that part of our zoning ordinance. That's not something I want to do.
Or not?
Yeah,
The vote was taken.
There was a vote taken, the
vote
motion did not pass,
The motion failed.
the motion failed, so no final action has been taken on the application.
That's right.
I'm just confused on what we're doing now.
Oh, we had a motion to grant the request. That motion failed.
Correct.
So, and I have not had a second motion presented to me, so we're still discussing. No decision has been reached.
Okay. Thank you for, I just want to clarify where we're at.
I understand your concerns about what our ordinance says about getting permission from the landowners, but I really do think that applies in situations where there's not an easement. So then we're back to the easement question, how that intertwines with
Yes, we are.
this particular issue.
So do you think the landowner, do you think that a person can erect any sign in an easement without the permission of the landowner?
No, I still think it has to meet our ordinance requirements.
All right, so it has to meet the size requirements and the lack of internal illumination and the other requirements of our sign ordinance. Is that the only thing that's
Well,
necessary for them to put up a sign in an easement?
There's testimony that this sign has been there for quite a while, so.
So are you treating this as a sign that requires a permit or not?
Well, I think I can take into consideration, even if it requires a permit, the fact that it is similar to or the same as signs that were there previously.
All right, well, it could be a totally different sign, but you're saying that they don't need a sign permit because it's on an easement. Is that right?
No, I'm saying they don't need the landowner's permission to put it up because they have the easement. It's the permission.
But isn't that a requirement of issuing the permit? I mean, our ordinance doesn't make an exception for it, except unless the sign is located on an easement. So how do we get to that exception that isn't written in the ordinance?
May I intercede something? Sure. In my mind, if we vote to approve this petitioner's request to deny the sign, we are not violating our ordinance unless it were to be taken to the next level of court and a judge determines that our ordinance violates something. If we vote to deny this petition, we are superseding our ordinance.
Yes, I
So,
agree.
one is definitely superseding our ordinance, the other may or may not, but that this board is, I don't know that, that's our job to determine. I think that would be on a civil court to determine.
Can I say something?
Yes, Jane.
I think if there had never been a sign there, if it wasn't the same sign that went back up, all of this would be necessary, the permission and everything else. It's already been proven that the sign has been there 20, 30, 40 years, I don't know. There's several other numbers put out there. So the fact that it's just putting the sign back up kind of grandfathers that in, yes or no? I don't know if that's the right term, but.
Well, it is. If I understand you right, you're arguing that grandfathering's, even though the parties involved understood that a sign permit would be necessary, if the sign ever came down and it were to go back up, a sign permit would be necessary. The grandfathering wasn't forever. You're arguing that you think grandfathering should have been forever for this sign.
No, because they got it.
I'd like to go to a point of order here.
Yes.
I think our work is done. We got a motion. There was a second. There's discussion. Vote was taken. And I think we have a resolution or finality to it. Did we not do that?
No, we did
You
not.
would need to make a motion to deny the appeal and have a majority agree to that. So, go ahead.
No, it's okay. Okay.
No, the original motion was to appeal, to grant the appeal, revoking the sign permit. That motion got 2 votes. It was, to be a final action, it would have had to have had 3 votes. So nothing happened, no official action was taken on that, or no final action was taken on the case before you. So if you want to move it forward, you would need to make a motion to say, we deny the appeal, and see if you get 3 votes. And if you do get 3 votes, then the appeal's been denied.
And I will make that motion. I move that we deny docket number 25-A-02.
And I will second that motion.
Okay. We have a motion that's been seconded to deny the petitioner's request to reverse the decision of the planning director to issue a sign permit. Is that clear to everybody? All right. Danielle, roll call vote, please.
Carla Brown,
Yes.
Randy Jones.
Yes.
Jane Gore,
Yes.
John Dilberger,
No?
Andy Boyles.
No.
All right. Your request has been denied. Thank you, everybody.
Thank you.
Did everybody get a chance to look at the proposed dates for our meeting next year?
Can we go out?
Probably, but I don't know.
Thank you, everybody, for your time.
Folks, thank you very much for your time. Appreciate it. Thank you. Thank you very much. Thank you very much. Thank you very much for your time. Kayla, thank you so much for your time.
Thank you.
You did. Then I move we accept the proposed dates for docket dates and meeting dates for 2026 for the BZA. Roll call vote when you're ready, Danielle.
Randy Jones,
Yes.
Jane Gore. John Dilberger,
Yes.
Andy Boyles,
Yep.
Carla Brown.
Yes.
Right. A reminder to everybody that our meeting in December is on a different date, same time, different date. The 18th, not the 17th.
Right. It's on Thursday.
December 18th?
Yes.
Yeah.
We've got 2 variances, and then the tourist home that we've had on the agenda the last 2 months.
Unless they want us to table it again.
I believe they can only table, they can request a table twice, I believe.
Unless they used up their.
I believe so. I'll check that too.
Dave, any announcements or anything for us?
No.
Oh, that's good.
Kayla, when's the APC meeting next month?
It is on its normal day, which is the 16th.
December 16th.
It's just this board that gets kicked out of the room.
Such a harsh term, kicked out.
I know.
All right, well, in that case, I did entertain a motion to adjourn.
I make a motion to adjourn.
I'll second the motion.
Okay.
Oh, now we agree.
Danielle, a roll call vote to adjourn, please.
Jane Gore,
Yes.
John Dilberger,
Yes.
Andy Boyles,
Yep.
Carla Brown,
Yes.
Randy Jones.
Yes.
This meeting is adjourned.